Say refers to evidence given by witness who do not speak from personal knowledge but merely repeats what someone else has said. According to the Black's Law Dictionary, it includes statements made outside court and later presented to prove the truth of the matter asserted. Hereby, hearsay can take different forms such as oral statement, written documents, or even gesture. Generally, hearsay evidence is inadmissible because it considered unreliable and weak, as the original speaker is not present in court to be questioned. Hearsay is rejected mainly because the original maker of the statement cannot be cross-examined. This prevents the court and the opposing party from testing the truth and accuracy of the statement. There is also a high risk of manipulation, exaggeration, or misunderstanding. Allowing such evidence would undermine fairness and the integrity of judicial process. In Malaysia, the hearsay rule is governed by Section 60, Clause 1 of Evidence Act 1950. This section requires that oral evidence must always be direct. If a fact can be seen, the witness must have personally seen it. If it can be heard, the witness must have personally heard it. Witnesses are not allowed to testify based on what others perceive. However, if a hearsay statement is not used to prove the truth of the matter asserted, but merely to show that that statement was made, it may be still relevant. The hearsay rule is grounded in the best evidence principle, which ensure that courts rely on first-hand and reliable testimony. A witness who gives direct evidence can be
Before going specifically into Section 32, Clause 1, Clause C of the Evidence Act 1950, it is important to first understand the general requirements under Section 32, Clause 1. This is because Section 32, Clause 1, Clause C must be read together with the overall framework of Section 32, Clause 1, and not in isolation. Section 32 of the Evidence Act 1950 is a statutory exception to the hearsay rule, and as a general rule, hearsay evidence is not admissible because the maker of the statement is not present in court and is not under oath and cannot be cross-examined. And this affects the reliability of the evidence and the fairness of the trial. Therefore, Section 32 only allows hearsay in limited and specific circumstances. And the courts have consistently held that Section 32, Clause 1 is to be applied strictly. The party relying on this position or provision must provide strict proof that the maker of the statement is genuinely unable to give evidence. In Sim QB against PP, a public prosecutor, the federal court made it clear that mere assertion of unavailability or incapacity are insufficient, especially in criminal cases where the right to cross-examine is fundamental. Under Section 32, Clause 1, hearsay may be admitted where the maker of the statement has died, cannot be found, or is incapable of giving evidence due to the old age, illness properly proven as stated in Chan Chal Singh against Emperor. Efforts and where a witness cannot be found, reasonable efforts to locate the witness must be shown, as seen in Public Prosecutor against Nur Faisal Mat. Now focusing on Section 32, Clause 1, Clause C, this provision allows hearsay where the maker is unable to testify due to incapacity or where the attendance would have unreasonable expense or undue delay. However, this exception is also strictly applied and interpreted in the case of Borneo at Senior Member Head against Penang Port Commission. The court allowed hearsay because the cost of bringing a foreign witness was unreasonable compared to the value of the claim.
In this part of the presentation, I will explain the strict requirements for admitting evidence under Section 31C of the Evidence Act 1950. This section provides an exception to the general rule against hearsay. It allows a statement, whether oral or written, to be admitted as evidence even though the maker of the statement is unavailable. This includes situations where the maker has passed away, cannot be found, is incapable of giving evidence, or where securing the maker's attendance will cause unreasonable delay or expense. However, such statements are not automatically admissible. The statement must be against the maker's own interests, meaning that if the statement were true, it will expose the maker to the criminal prosecution or a civil suit for damages. If you refer to the case PP against Forster Frank Adel Henrich, the court clarified that the maker does not need to be convicted for the statement to fall under this section to be admitted. It is sufficient that the statement exposed the maker to the risk of prosecution during his lifetime. The law does not distinguish between a high or low risk of prosecution, and the focus is on the possibility of prosecution rather than the likelihood of conviction. The underlying rationale for admitting such a statement was explained in the case of Ni Choi Ko against Ishoda, where the court adopted the principle that a person is unlikely to make a statement that is detrimental to his own interest unless the statement is true. This principle forms the basis for the reliability of statements against interest. Despite this rationale, the courts have imposed strict requirements to ensure fairness, as the maker of the statement cannot be cross-examined. The first requirement is that there must be no motive behind the statement. If the maker had a reason to benefit from making the statement, then the statement should not be admitted. This was highlighted in the case of Taylor against Whitham, where the court emphasized that even a statement appearing to be against interest may be unreadable if made with a hidden motive. Second, the maker must have personal knowledge of the facts stated. In the case of Walls against Pitt, the court rejected the statement because there was no proof that the maker actually knew the facts being asserted. This shows that statements based on speculation or assumption are inadmissible. The third requirement is awareness of the interest. The maker must be aware at the time the statement was made and not retrospectively that it was against his own interest. In the case of Tucker against Albury, the statement was rejected because there was no evidence that the maker knew his statement could affect his legal right at that time, which is he can do claim. Finally, as emphasized,
So under Section 32, Clause 1, Clause C, specifically, the party who wish to rely on the statement must prove to the court that the statement on its natural meaning is against the maker financial interest or against the maker proprietary or legal rights, or, if true, it will expose the maker to criminal prosecution or civil liability, and this must be shown prima facie, meaning on the face of the statement, without relying on external explanation. For the first case, which is the Sing Hong Huat industry, the legal burden lay on the plaintiff as it were asserting the right to indemnity under the insurance policy. So under Section 101 of the Evidence Act 1950, the plaintiff had to prove on the balance of probability that the loss was covered and that all policy warranty were complied with. So when the defendant insurer alleged a breach of fire safety warranty, an evidential burden arose on the defendant to prove the breach. So this burden was discharged through investigation report, expert evidence, and statement from the plaintiff partner and foraging worker. And a further burden arose under Section 32 of the Evidence Act when the defendant relied on the hearsay statement, which is the defendant proved the maker unavailability, Mr. Sri Ganesa, and the statement were against the maker pecuniary interest, and the statement were admitted. So the evidential burden then shifted to the plaintiff who failed to rebut the evidence. Accordingly, as the plaintiff failed to discharge its legal burden, the claim was dismissed. So in the case of Kiong against public prosecutor, in this case, the defense, which is the Kiong, sought to admit a document known as SITI-1 by relying on Section 31, 32, Clause 1, Clause C of Evidence Act 1950. As SITI-1 contained a statement by a lawyer alleging that prosecution witness 15, the rape victim, had later admitted that she lied about the rape. To succeed, the defense was required to show that the prosecution witness 15 was unavailable, that the statement was a prima facie against her interest as it could expose her to some criminal liability, and that the statement was reliable also. So the court held that none of these requirements were fully satisfied. The prosecution witness 15 was still alive and had testified that the statement was not clearly against her interest and was unreliable as it contradicted her earlier testimony, medical evidence, and contemporaneous report. So the statement was therefore rejected as it immiscible hearsay. In the absence of SDT1, which is the statement, the defense failed to raise a reasonable doubt, and the prosecution case remained proven beyond reasonable doubt. For the first case, which is the Sing Hong Huat industry, the legal burden lay on the plaintiff as it were asserting the right to indemnity under the insurance policy. So under Section 101 of the Evidence Act 1950, the plaintiff had to prove on the balance of probability that the loss was covered and that all policy warranty were complied with. So when the defendant insurer alleged a breach of fire safety warranty, an evidential burden arose on the defendant to prove the breach. So this burden was discharged through investigation report, expert evidence and statement from the plaintiff partner and foraging worker. And a further burden arose under Section 32 of the Evidence Act when the defendant relied on the hearsay statement, which is the defendant proved the maker unavailability, Mr. Sri Ganesa, and the statement were against the maker pecuniary interest, and the statement were admitted. So the evidential burden then shifted to the plaintiff who failed to rebut the evidence. Accordingly, as the plaintiff failed to discharge its legal burden, the claim was dismissed. So in the case of Kiong against public prosecutor, in this case, the defense, which is the Kiong, sought to admit a document known as SITI-1 by relying on Section 31, 32, Clause 1, Clause C of Evidence Act 1950. As SITI-1 contained a statement by a lawyer alleging that prosecution witness 15, the rape victim, had later admitted that she lied about the rape. To succeed, the defense was required to show that the prosecution witness 15 was unavailable, that the statement was a prima facie against the interest as it could expose her to some criminal liability, and that the statement was reliable also. So the court held that none of these requirements were fully satisfied. The prosecution witness 15 was still alive and had testified that the statement was not clearly against her interest and was unreliable as it...
A useful way to understand Section 32(1) Clause C of the Evidence Act is to see how strictly courts require the party with the burden of proof to establish every element of the exception before admitting hearsay. The provision creates a statutory exception to the hearsay rule, allowing certain statements to be relevant and admissible even though the maker cannot be called as witness, provided that the statement is either against the maker's pecuniary or propriety interest or is of such nature that when true, it would expose the maker to criminal prosecution or a suit for damages. So the operation of Section 32(1)(c) can be seen in several cases. First of all, in Public Prosecutor and Foster Frank, the accused, a German tourist, was charged with trafficking cannabis found in his shared hotel room. His two German companions had already left Malaysia at the time, and so they could not be called as witness. So the defense relied on two affidavits sworn overseas by these companions, and in which they admitted that they alone had bought, possessed, and used the cannabis. So the court treated these affidavits as statements against the maker's penal interest and admitted the affidavit under the second limb of Section 32, Clause 1, Clause C, and the accused was ultimately acquitted. So from this case, this shows how Section 32(1)(c) operates when the requirements are met. That is, first of all, the makers cannot be called as witness, and the second of all, the statements are clearly self-inculpatory and it exposed them to criminal prosecution. Next, in the case of Sing Hong Huat Industries and Berjaya General Insurance, the plaintiff's factory was insured under a fire policy containing the fire extinguisher appliance warranties. So after a fire, the insurer repudiated liability, alleging breach of those warranties. So the insurer relied on statements given to a loss adjuster by a partner of the plaintiff and several workers effectively admitting that the factory did not comply with the fire safety requirements. And in the end, the court admitted these statements under Section 32(1)(c) because the makers could not be called as witness and the contents were clearly against their pecuniary interests as they supported the insurance reputation and weakened the plaintiff's claim. A useful way to understand Section 32(1) Clause C of the Evidence Act is to see how strictly courts require the party with the burden of proof to establish every element of the exception before admitting hearsay. The provision creates a statutory exception to the hearsay rule, allowing certain statements to be relevant and admissible even though the maker cannot be called as witness, provided that the statement is either against the maker's pecuniary or propriety interest or is of such nature that when true, it would expose the maker to criminal prosecution or a suit for damages. So the operation of Section However, Section 32, Clause 1, Clause C is not given automatically. In Sim 2B and Public Prosecutor, the court stressed that a party must first prove with independent evidence that the maker is dead, or the maker cannot be found despite diligent search, or the maker might be incapable of giving evidence, or the maker cannot reasonably be brought to court. If these preconditions are not proved, the statement remains inadmissible hearsay. So, in the case of Yong, Choo, Kiong, and public prosecutor, the defense tried to rely on a written statement by an Indonesian lawyer, claiming that the statement fell under the second limb of the Section 32, Clause 1, Clause C, because, if true, it would expose the victim to criminal prosecution for giving false evidence. So, the federal court held that the requirements of this section were not satisfied, and the statement was held inadmissible. So, overall, this case shows that while Section 32, Clause 1, Clause C creates an important exception to the hearsay rule, the courts applied it very strictly, and it will only admit statements where every statutory condition is clearly proved.
We explain why the court adopt a strict approach in applying Section 32 Clause 1C of the Evidence Act 1950. Although Section 32 Clause 1C operates as an exception to the hearsay rule, the court consistently emphasized that it must be applied cautiously. This is because hearsay evidence is inherently unreliable and, if admitted too easily, may undermine the integrity of the trial process. Firstly, the strict requirement is justified to prevent the risk of abuse. In SITI against public prosecutor, the court refused to admit the statement because the party relying on it failed to prove the maker's unavailability. This showed that without strict safeguard, parties could fabricate or rely on self-serving statements allegedly made by absent person. Similarly, in Yong Choo Kiong against public prosecutor, the federal court stressed that the precondition under Section 32 must be strictly proved to avoid misuse of the hearsay exception. Secondly, the strict approach also protects the right to a fair trial. In a public prosecutor against foster frank adult he enriched, the court admitted affidavit made by the accused companion who were abroad, as the statement were clearly self-inculpatory and therefore reliable. This demonstrates that the court are not rigid, but rather seek to ensure their fairness by admitting reliable evidence when exclusion would cause injustice. A similar approach can be seen in Sing Hong Huat Industry against Berjaya General Insurance, when statements against pecuniary interests were admitted because they were necessary and trustworthy. Finally, strict scrutiny is necessary due to the loss of cross-examination. Statement admitted under Section 32 Clause 1C deprive the opposing party of the opportunity to test the maker's credibility. Therefore, the courts only allow such statements where there are strong indicators of reliability, such as self-inculpation or pecuniary disadvantage, as seen in Foster Frank and Sing Hong Huat. In conclusion, the strict application of Section 32 Clause 1C serves as an essential safeguard in prevent abuse of the hearsay exception, ensure fairness in the trial process, and mitigates the absence of cross-examination, while still allowing justice to be achieved in cases of genuine necessity.
Section 32 Clause 1 of Evidence Act, which provides limited statutory exceptions when a witness is unavailable due to death, absence, or unreasonable delay or expense. Among these, Section 32 Clause 1C permits the admission of statements made against the maker's own interest based on the principle that individuals are unlikely to make self-damaging statements unless they are true. These exceptions are applied cautiously where court require strict proof of witness unavailability, genuine efforts to secure attendance, and assurance of the statement's credibility. As shown in Yong Choo Kiong against PP, Section 32 Clause 1C cannot be used to bypass the hearsay rule. Ultimately, the courts carefully distinguish between admissibility and evidential weight to balance the need for justice with protection against unreliable evidence. Section 32 Clause 1 of Evidence Act, which provides limited statutory exceptions when a witness is unavailable due to death, absence, or unreasonable delay or expense. Among these, Section 32 Clause 1C permits the admission of statements made against the maker's own interest based on the principle that individuals are unlikely to make self-damaging statements unless they are true. These exceptions are